Judgment in the appeal, Zoumbas and the Secretary of State for the Home Department.
Lord Hodge will summarise the judgment of the court.
This appeal concerns an application for judicial review of an immigration decision by the Secretary of State for the Home Department. She decided that Mr. Zoumbas did not qualify for asylum or humanitarian protection, and that his further representations were not a human rights claim under paragraph 353 of the immigration rules. Mr. Zoumbas relied on a claim under Article 8 of the European Convention on Human Rights to argue that the Secretary of State had erred in her decision because the removal of him and his family was a disproportionate means of achieving proper immigration control. In particular, he argued that the Secretary of State had failed to treat the interests of his 3 children as a primary consideration in the assessment of proportionality. Mr. and Mrs. Zoumbas are both illegal immigrants. They have an unedifying immigration history involving the use of false passports or other documents, and in the case of Mr. Zoumbas, absconding when his wife and eldest child were removed from the United Kingdom in 2005. Mrs. Zoumbas and that child, Ange Marcel, returned to the United Kingdom, again using false documents, in 2006. Mr. and Mrs. Zoumbas' claims for asylum were refused, and their appeals were dismissed. Mrs. Zoumbas has given birth to 2 more children since 2007, and Mr. and Mrs. Zoumbas' 3 daughters were aged 7, 4, and 5 months at the time of the Secretary of State's decision. They have lived as a family in Glasgow. At the core of Mr. Zoumbas' challenge to the Secretary of State's decision was the assertion that she had decided to remove him and his wife before she considered what was in the best interest of their children, and that it was irrational to think that the children's best interests would be served by their removal with their parents to the Republic of Congo. The court holds that the first assertion is a misreading of the Secretary of State's decision letter in which she set out her decision and then gave her reasons. We stress in the judgment that it is important to construe such decision letters as a whole so that one can see individual passages in their context. A decision maker can choose to state in a letter the outcome of her prior reasoning before setting out that reasoning, as the Secretary of State has done in this case. In rejecting the other challenges, we take the opportunity to clarify the effect of the well-known decision of this court in ZH Tanzania. We discuss in paragraphs 10 to 13 of this judgment the principles to be derived from that and 2 other recent cases which this court has decided. The treatment of the interests of the children when deciding whether to remove a family does not involve the application of hard-edged rules, but is an evaluative exercise. While it may be the case that the children would enjoy better education and healthcare in the United Kingdom than in the Republic of Congo, they, as Congolese citizens, have no entitlement to such benefits. Certain of the dicta in ZH Tanzania should be seen in their proper context, which is that that case involved children who were British citizens and who were entitled to the benefits which that citizenship confers. In this case, when one has regard to the ages of the children, their Congolese citizenship, and the fact that their integration into the United Kingdom has taken place in the context of their close family unit, it was not irrational for the Secretary of State to hold that their best interests are served by their removal to the Republic of Congo with their mother and father. We therefore dismiss the appeal.
The court is now adjourned.